Good afternoon, Aisha Khan, counsel for Carmen, in response to Matt Miller, counsel for NOI's argument. I would like to say that, Mr. Miller, you were articulate in your argument, although ultimately we disagree with the conclusion. And I would like to address your arguments in sequential order. First, you mentioned that the metadata discoverability should be covered by work product. I would like to point out that the metadata that Carmen found, and specifically the email which stated, verify with lit funds whether any contacts between Bill Prasad and them exist. If any such contacts exist, we should make sure to keep the third-party funding of our client's litigation secret and avoid any challenges to Bill. Bill was the Barbary presenter when I was taking the bar exam, though he probably wouldn't remember me. Anyway, his views on the enforceability of ethical sourcing standards in his 2014 academic article are great for our client. Now, this metadata was discovered through an email that was sent from NOI's attorneys to Carmen. It cannot be covered by attorney-client privilege because it was sent from NOI to Carmen, and therefore it would not be our responsibility to keep secret or work product what was sent to us by your firm. Secondly, in regards to that matter, the work product doctrine is different than attorney-client privilege. The purpose of attorney-client privilege is to encourage clients to make full disclosures to their attorneys, while the purpose of the work product doctrine is to establish a zone of privacy for strategic litigation. However, unlike the attorney-client privilege, which provides absolute protection from disclosure, the work product doctrine is qualified and may be overcome by need and undue hardship. And we're not necessarily claiming undue hardship here, but I would just like to remind you that, again, this metadata was discovered by our firm through an email that was sent from your firm. So again, the responsibility of keeping that information, including the metadata, confidential would fall upon NOI and NOI's counsel. Second, you suggested that the relationship between arbitrator Prasad and lit funds was akin to that of someone having a checking account at Wells Fargo and having a relationship with the person who designed the Wells Fargo lobby. I would wholly disagree with that. Here we have established that lit funds will actually be funding part of this arbitration on behalf of NOI. As well, Mr. Prasad has previously on 2 occasions in the last 2 years worked on cases where lit funds at least partially funded those arbitrations. For that reason, there is a substantial relationship, and one where potentially arbitrator Prasad does have a financial relationship and potentially something to benefit from this arbitration. And so that should have been disclosed, and now that it is officially disclosed through the additional disclosure, we believe that we have a valid objection here. Third, you mentioned that the article that he wrote regarding against the enforceability of responsible sourcing clauses is something that we should have objected on previously. Now, this article shows clearly that he has a position on the exact subject matter that is being arbitrated here between NOI and Carmen. And we feel that it would have been the responsibility of arbitrator Prasad to bring forward, not specifically just send all the articles that he had ever written, but to specifically mention that he has an opinion on this exact subject matter that is to be arbitrated, and that he in fact is not impartial into the terms of which are being arbitrated and really are at the foundation of this dispute. It would be asking a bit much to ask a party to an arbitration to read every article that Mr. Prasad had sent. In this case, he sent, I believe, a dozen articles, of which only one was seemingly relevant, and perhaps his intention of sending all of these articles was to bury the one relevant article. And for that reason, we, again, have deep concerns about his impartiality. Finally, and this may be the least of our concerns, but it would have been in his best interest to disclose his role as a Barbary presenter. In itself, a Barbary presenter may not build relationships with attorneys who come and pass through the classroom, and we understand that. However, combined with the fact that NOI attorney Ford attempted to conceal this, and the fact that Mr. Arbitrator Prasad failed to disclose, is cause for concern. As you know, Section 12C and D of the RUAA both state that upon a party's timely objection, with cause, which we believe we have here, an award may be vacated. It would be in neither party's best interest to go through the arbitration process only to have the entire award vacated and to begin the process again. For that reason, we respectfully ask that you consider replacing Mr. Prasad, or that Mr. Prasad actually recuse himself in this case. Thank you for your time.